Okay, so let's dive into this story. It's about a dispute in a pretty quiet neighborhood, but it brings up these huge questions about power, money, and really what it even means to own a home. We're talking about a homeowners association, a massive multi-million-dollar plan, and this really fundamental fight over who gets the final say. And it all kicks off with something people really loved about their neighborhood. You hear it right there from homeowner Taylor Kidd. For her and a lot of her neighbors, the whole reason they bought into this community was because of the green. All this lush grass, it was a total escape from that typical desert granite look you see everywhere else. It was their identity, you know? Yeah, but that green, idyllic vision, it was about to get a huge price tag. The whole debate just exploded when the homeowners found out what this change was going to cost them. We're talking almost $10,000 for every single household. That one number right there changed everything. This wasn't about what looked nice anymore. It was a serious fight about money. So what exactly was the HOA board planning here? Look, this was way more than just planting a few new bushes. This was a massive multi-million-dollar overhaul, a whole new vision for the entire community's future. It all started with a letter that showed up right before the holidays in December 2023. The board announced what they called a landscape improvement project. They sent it to all 166 homeowners, and it laid out this plan for a huge overhaul of all the shared common areas. And when I say huge, I mean huge. The total cost was over $1.5 million. The plan? Rip out big chunks of that green grass everyone loved, put in decomposed granite and native plants instead, and, to be fair, upgrade an irrigation system that was literally 40 years old. Now, the board's argument was, hey, this is a smart move. It'll conserve water, and it's going to increase property values. But check out this timeline. It was, wow, super aggressive. Homeowners get this letter right before Christmas, and they're supposed to have almost 10 grand ready to go by February 1st. And then the work was scheduled to start just 11 days after that. You can just imagine the panic and the stress that would cause, right? So, no surprise here, this whole thing just split the community right down the middle. But it wasn't just about the money or whether they liked grass or granite. The real fight was about the rules that are supposed to govern the whole community. And that leads us to the absolute core of this whole conflict. Who gets to make a call this big? Did the board have the authority to just do it? Or was this project so massive that it needed a vote from the homeowners themselves? Okay, so this is where it gets into the weeds, legally speaking. You had two totally different interpretations. On one side, the homeowners are saying, whoa, this is a capital improvement, basically a massive upgrade. And according to their community rules, something that big needs a 2/3 vote from all of us. But the HOA board, they called it maintenance and repair. They argued, nope, we're just doing our job, maintaining the common areas, and for that, we don't need a vote. The whole case literally came down to which of those two phrases was the right one. So yeah, that term, capital improvement, it's everything here. Think of it this way. It's a project that adds substantial value or extends the life of something. It's not just fixing what's already there. And the big question was, does a $1.5 million total landscape makeover count? Homeowners were screaming, yes, obviously, and the board was saying, nope, not at all. Okay, so with nobody backing down an inch, this thing moved out of angry community meetings and into a formal administrative hearing. It was time for both sides to make their official case in front of a judge. For the homeowners, their lawyer kept it simple. They basically said, look, this is a textbook case of a board overstepping its authority. They're trying to force through a huge project with a huge price tag, and they're ignoring their own rulebook that says they need a vote to do it. But the HOA's lawyer had a sharp comeback. They said, wait a minute, we haven't collected any money, we haven't dug up a single blade of grass, so technically we haven't broken any rules yet. They were basically arguing that the homeowners were jumping the gun, filing a complaint before anything had actually happened. And you can really feel the anxiety in this quote from homeowner Jerome Glazer. For him, this was about way more than just plants. It was about the precedent. It's that classic slippery slope fear. If the board gets away with this, what's next? A brand new gym that costs everyone 20 grand? He was terrified that this one decision could wipe out all the equity in his home. But on the flip side, the board saw this as their duty. A board member, Jennifer Hutsko, got up and said, listen, our irrigation system is over 40 years old. It's failing. We have to do something. And her take on the whole voting issue was really interesting. She basically said, the vote already happened. You all elected us to the board to make these tough decisions. That was the vote. So there you have it. Two totally different reads on the same rules. Two completely opposite visions for what this community should be. After listening to all of this, the judge had to go back, look at all the evidence, and make the final call. All right, so the moment of truth. What did the judge decide? After all the arguments and all the waiting, the official decision finally came down. So in the end, the judge sided with the homeowners. The final ruling came down and basically invalidated that huge special assessment. The decision found that the board just didn't follow the right steps laid out in their own governing documents for a project this big. So, long story short, the $1.5 million plan was dead in the water. It couldn't move forward unless they went back and got that 2/3 vote from the homeowners. But look, this isn't just about one neighborhood's fight over landscaping. This whole story really gets at a core conflict you see in HOAs all over the country. So let's zoom out and talk about why this case really matters. What this all comes down to is this constant balancing act that every HOA has to deal with, right? You've got the board of directors, and they have a legal responsibility, a fiduciary duty to keep the place up and think about the future. But then you have the homeowners, and they have rights too. The right to be protected from these giant out-of-the-blue assessments, and the right to have a say in major changes that impact their homes and their money. Really? It's this classic struggle, isn't it? Preserving the community you fell in love with versus being forced to change it. And the homeowners are always stuck right in the middle. I think the biggest takeaway here is that if you live in an HOA, you have got to know your governing documents inside and out. I mean, this whole $1.5 million fight boiled down to how you defined just a couple of words. And that's the big question this whole thing leaves us with, right? For any community, where do you draw the line between just maintaining a place and completely transforming it? This goes so much deeper than just grass versus granite. It's really about who has the power to decide a community's future and what that costs the actual people who live there. And it's a question that, honestly, anyone living in an HOA might have to face one day.